So what's up, y'all? We're here at Lackluster's channel right now. We're checking out cop caught lying in court, huge lawsuit. So let's go ahead and get started. See what we got here.
Get arrested. You've been notified once.
Really? I just been threatened by the sergeant. I'm gonna be arrested on a public street. I dare y'all to lock me up. I'm addressing all of y'all.
Put your hands behind your back.
For what? What did I do?
Fortunately for Mr. McCullough, both the Rhode Island and United States constitutions protect his freedom to express himself precisely how he did last October.
Welcome back to the Lackluster channel. In October of 2020, John McCullough from the channel The Resistance had heard of a protest because of alleged police brutality. He made his way down to the scene, but upon his arrival, the protest was over, and as he began filming, several officers told him to leave or he would be arrested.
Got a busted window here. They got a busted window here. Stay to the side? For what? For what reason? I could walk this whole street. I could walk this. All right, so what's the problem? All right, well, don't tell me to do nothing. Yeah, I busted a window over there.
You gotta clear out of here. All right, we just dispersed everybody. You need to leave.
And the only reason they are approaching him right now is one, because he's recording, and two, because he's narrating or basically using his First Amendment right, free speech. They just, for some reason, they just don't like free speech. They don't like you to say what you want to say. They want everything quiet, and it's crazy.
All right, we're not doing this. Stop walking.
Stop
walking.
There was absolutely no reason for them to come over here and try to do what he's doing right now. Absolutely no reason.
Get arrested. You've been notified once.
Really?
All right,
Okay.
take off.
Okay.
I'm done with you. Get out of here.
Mm-hmm.
You come back, you're getting arrested.
On the public street? On the public street?
You've been notified.
On the public street, I'm gonna get arrested?
That's a sergeant too.
I don't see no tape, but
We're about to put it up.
John followed the officer's commands and backed up to an appropriate area and continued to shout his protests at the officers.
I just been threatened by the sergeant. I'm gonna be arrested on a public street. How does that go? I'm here for no ill intent. Got flat tires, busted windows, ladies and gentlemen. Flat tire over here. They butthurt. They told me to get up out the situation or he's gonna arrest me, and he was only telling me one time.
After standing in the same place for about 14 minutes and being completely ignored by the officers, Officer Flavio Tavares had his feelings hurt to the point that he exceeded the constitutional limitations to his authority and effected a false arrest, taking John into custody for disorderly conduct.
Y'all gonna hear about it. It's all documented. Y'all wanna lock me up? It's documented. Federal lawsuit coming y'all way. I dare y'all. I dare y'all to lock me up. I'm addressing all of y'all.
Look at him. He just got to step to it.
Put your hands behind your back.
For what? What did I do?
Get off.
What did I do?
Get your hands behind your back.
What did I do?
Get your hands behind your back.
What is your first and last name?
Get him out of here.
What's your name? You didn't do a damn thing.
The resistance on YouTube. I didn't do anything, y'all.
Providence Police Department costing the taxpayers hundreds of thousands, if not millions of dollars.
John McCullough. Yes, John McCullough. I'm from Boston. Right here.
Check his bag. I'm creating a scene to get my car. You're being arrested.
From Unit Street at the Speedway gas station area, outbound on Manhattan. Any cars are in the area.
He said the magic words. Let's go. Let's go. You got it. Lights and sirens. Let's go.
Disorderly.
So I guess the magic words was "I dare you," and they always use that with us. And because they're in a position that they're in, when they dare us to do something, they know we're likely not going to do it because They're not just daring us, they're threatening us. So when we dare them, they feel like they have all the power in the world, so they'll do whatever dare that they come up with, or that we come up with.
I was at disorderly. What kind of disturbance did I create? Who's the complainant, sir? All this will be addressed in court. It's not an inconvenience for me.
John was held for nearly 14 hours before he was released on his own recognizance, and it took nearly a year for the court to hear his case. During the trial, Officer Flavio testified that John was yelling things like, "Aim at their heads," and "Uncle Tom officers."
What really caught my attention is, as I was speaking to a supervisor at the time and some of my colleagues on essentially what just took place, was that words of, aim at their heads, swear words towards us. That's what caught my attention, to look in that area. And that's when I noticed that he was clearly the loudest one, or the one that demonstrated he was not happy with us.
Also, one of those things that you observed him shouting was aim at their heads.
So as I stood there, I heard the words and then I looked, ma'am.
How many times do you recall him yelling aim at their heads?
I wouldn't recall more than once, ma'am. I think I just heard it once.
When you heard that, what did you take that statement to be?
I'm pretty sure as I was speaking to my colleagues, I think I mentioned something to the effect of, not again, or here we go again, or something like that. I mean, we couldn't go through that again. We literally just did this. We dispersed everyone. I personally, I know I was tired. I just went through, dispersing crowds with everyone else. It's just one man staying on the sidewalk. If he wants to continue to rant, that's fine. But it became a concern when other people started, gathering again. So that's really what prompted me to just put that to an end.
However, John's lawyer destroyed the notion that he used that type of language during the officer's cross-examination.
He was saying some pretty rude things, right?
That's right, sir.
Pretty offensive things.
Sure.
And annoying things, too.
Sure, but that's normal in the life of a police officer, I suppose.
It's fair to say you didn't appreciate hearing these things, though, right? You don't enjoy hearing words like that.
It's just words, sir.
But you don't enjoy hearing them. And you actually, before that arrest, you actually didn't talk to him at all that night, right?
That is correct, sir.
Not a single word.
No, sir. From the moment that I actually put him in cuffs, took him to the vehicle, and that was it. That was the end of it.
That was it.
Yes, sir.
Okay. And you're certainly not the officer who said the magic words, right? That didn't come out of your mouth.
I'm not sure, sir. If I could hear the voice again, I don't recall myself saying that.
Yeah, here they go with not recalling what they said. A lot of times they forget that they're on body cam, or it's not that they forget that they're on body cam, or that everything's being recorded. It's that you can only hide yourself for so long. It's gonna slip up, and it happened. So yeah, this was man. As soon as they get into court or the depositions, here go the lies. Here go the authority and all that bass that was in their voice is gone away. They try to act like they're humble now. They want to be either meek about what they're saying, or they like to play the I don't know anything game. Or they try to act like, oh, I don't recall me saying that. I don't recall me not liking the words that, it wasn't just about my ego of why he's arrested. Come on now. We know this was a pure ego move, just because they didn't like what he was saying and they was tired of him saying it. So they felt like they wanted to shut him up. And how they do that is by putting you in cuffs and taking you to jail. And hopefully They can throw as many bogus charges on you to see what sticks and ruin your life. That's pretty much it. And to get you to respect authority and never do that again. That's the whole game plan.
But if I could hear it.
You can hear the voice? Yeah.
Sure.
You said the magic words.
Sounds like me, sir. Sounds like I'm the one that said it.
Oh, that sound like you.
Yes, sir.
Okay, so you in response to Mr. McCullough's arrest, the moments right after Mr. McCullough's arrest, he said the magic words.
Yes, sir.
Okay.
He said the magic words.
John's attorney then played the full video and made note that the phrases "aim at their heads" and "Uncle Tom officer" were mysteriously absent from the recording.
Huh? How you feel about that?
So even if he did, well, the "aim at their heads" is, that's, I don't know about that phrase, but calling him Uncle Tom that's not grounds to cancel somebody's free speech.
Yeah, talk to the camera. You talked to the camera just a few moments ago when you threatened to lock me up. You're a real piece of shit.
You'd agree with me that that video that we just saw is a fair and accurate depiction of your encounter with Mr. McCullough on the corner of Bissell and Elm on the evening of October 21st, 2020.
Looking at the video, yes, but that is not the memory that I had in terms of what he said.
You would agree with me that that video is a fair and accurate depiction of your encounter?
Yes, sir.
His attorney then presented a strong closing argument.
People of the state gathered to express their grief and anger over the officer-involved moped crash. A number of those people formed crowds and became violent, but not all of them. Most were peaceful, most were nonviolent. Most did not pose a threat. And most of these people had left by the time officers became aware of Mr. McCullough's presence. Mr. McCullough is not here today for throwing bottles, for throwing bricks, fireworks, flares, or rocks. Mr. McCullough is before the court today accused of disorderly conduct for simply speaking. Fortunately for Mr. McCullough, both the Rhode Island and United States constitutions protect his freedom to express himself precisely how he did last October. So let's talk about that expression, about those words, and about how we know they're protected speech. Starting with Mr. McCullough's words. As he was documenting the damage to Providence police cars on Elmwood Avenue, an officer gave him two options: leave or be arrested. Ultimately, he followed the officer's order, regardless of its lawfulness. He left where he was filming. Officers ignored him for over 14 minutes, and he continued to express his shock and dismay resulting from the officer's actions. Y'all gonna arrest people on a public street. I'm not breaking any laws. I was threatened by the sergeant. I'm going to be arrested on a public street. Several other people joined Mr. McCullough on that corner. He continued to express his disappointment in the police behavior. Throughout this, Mr. McCullough continues to film. Police come and go. They mill about, unperturbed by Mr. McCullough's comments. Minutes pass. Mr. McCullough continues. You guys hate transparency so much that you'll illegally threaten to lock them up. He uses profane language. You're a piece of shit, cold-blooded pieces of shit. Your Honor, apparently within these comments were the magic words, as we heard from the video from Officer Tavares. Because within moments, Providence Police made good on their threat to lock Mr. McCullough up, despite Mr. McCullough moving to the corner when he was told to leave the spot next to the damaged police cars. He was arrested, Your Honor, for those magic words. Magic because they evoke the ire of Providence Police? Certainly yes. Magic because say them and poof, you're arrested? Yes again. Magic because they're accepted from constitutional protection? No. 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 The Constitution, Your Honor, knows no such magic words. And for that reason, the disorderly conduct statute under which Mr. McCullough is charged cannot be used to suppress his speech. Our courts have traveled down this road before, and fortunately for Mr. McCullough, it is a well-worn path. Today, I highlight 3 mile markers erected by the Rhode Island Supreme Court, 3 cases that defend Mr. McCullough's unqualified right to express himself precisely how he did. Now, the city has stated that Mr. McCullough is charged under subsection 3 of Rhode Island's disorderly conduct statute. I'll nonetheless very briefly highlight for the court what the Rhode Island Supreme Court held in State v. Cavarossi. The court held that subsection A2 of the disorderly conduct statute then in effect at the time, A2 prohibiting loud and unreasonable noise, does not apply to speech. The volume of Mr. McCullough's speech cannot be used against him in this case. The court in that case asserted that the state may restrict, quote, only those words tending to provoke violence, quote, language belonging to the fighting words class. A person's language cannot be punished as fighting words simply for being profane because, who's quoting again, it is often true that one man's vulgarity is another's lyric, end quote. Additionally, unlike McKenna, his remarks did not concern the officers individually. The officers did not visibly react at all until moving in to arrest him. A state may not punish the use of words that merely elicit indignation, disgust, or anger from the addressee. Mr. McCullough interrupted and irritated the officers as they were attempting to do their jobs. He was not the reason for their initial decision to come to the scene. He showed up after they were already there and was arrested merely for being an annoyance. That isn't disorderly, Your Honor. That's a protest. He made his voice heard. He made his presence known. He was nonviolent. The violence had ended almost an hour earlier. He moved when asked. Police should have expected and did expect comments like those made from Mr. McCullough that night. Comments like his and comments far worse. And Your Honor, we heard some of those far worse comments from Officer Tavares. We heard Officer Tavares testify that he first observed Mr. McCullough on the corner of Bissell and Elm, and that from that corner, Mr. McCullough yelled, aim at their heads, fuck the police, Uncle Tom officers, and field N-words. Whether those particular words were sufficient to evoke a violent reaction from either the officers or fellow protesters, thankfully, is not a question before the court. Because everyone present here today knows that Mr. McCullough did not utter those words. Officer Tavares' testimony attributing them to Mr. McCullough is simply erroneous. Now, he may be honestly mistaken. This happened almost a year ago. It was a chaotic night. He told us on direct that he was tired. And he quite obviously remembers none of what was said, despite independently reviewing Mr. McCullough's video on the internet. But regardless of the reason for Officer Tavares.
Yeah, man. So this lawyer is doing a great job calling him out on, BS. So he's claiming to not remember nothing about this night and, the whole spiel that they always give. Yet he actually watched the YouTube video and I'm sure he watched the body cam footage, just like everybody in that department. And it's not just him that watched the video. It's everybody in the department has watched the video. And for them to watch that video, I wonder, did it even make an impact? Did they look at that video and say, dang, we messed up, or dang, we got caught?
There's testimony. We have video evidence in this case. The video does not lie. Those were not Mr. McCullough's words. And paradoxically, Your Honor, Officer Tavares himself wasn't particularly perturbed by Officer Tavares' words that we heard for the very first time on direct. According to him, such words are, quote, normal life of a police officer, I suppose, and quote, just words, sir. And as we also heard from the video, Mr. McCullough missed the protest. He wasn't a part of the large group of protesters that was ordered to disperse. He regretted not being there. He regretted not capturing the action for posterity. He was there filming that night. When he arrived on the corner of Bissell and Elm, there were a small handful, less than a dozen people remaining, observing the police as they went about their business. His arrest was the result of that conduct, Your Honor. The conduct that we observed at the corner of Elm and Bissell, conduct squarely within the protection of the First Amendment. Yet for that conduct, Mr. McCullough has suffered dearly. He was arrested that night. He's been on bail for almost a year. He's had to make numerous trips to this courthouse from his home in Boston. The city has had access to exonerating video for well over a month, and yet we're still here. Let us today begin to right the wrong that Mr. McCullough has suffered by honoring the principles on which this country was founded. Principles that are Mr. McCullough's birthright. His right to assemble, his right to peacefully protest state action. Your Honor, for these reasons, for Mr. McCullough's conduct.
Not only are these his birthrights, the officers that arrested him swore to uphold these rights. Every last one of them. Every last one of those officers took an oath and swore to uphold this Constitution. And remember, when them swearing in is a ceremony. It's not just, oh, you know, no, it's a ceremony. They call it a historic day.
For the city's inability to prove any crime here by any standard, let alone beyond a reasonable doubt, the highest standard known to law. And Your Honor, for the deep chill that a conviction would send to others similarly and sincerely aggrieved and in desire of a public forum to peacefully express their grievances. We pray that this court will find Mr. McCullough not guilty.
Thank you, Mr. Francisco.
And finally, the judge found John not guilty, but not without justifying the officer's actions.
Oh, man.
City of Providence versus John McCullough, case number 6.
So now the judge is gonna judge explain for the cops. The judge is gonna, I'm assuming, gonna, well, you know, you got to understand that, you know, blah, 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 blah. No, we don't have to understand that. The law is the law. And when something happens to us with the law, they say ignorance is no excuse. And you know, it's the law is the law. But when it comes to the officers, well, you know, you got to understand, blah, 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 blah. They have a difficult job and, you know, all the extra BS, man.
6120-08966. There's one count charge in this complaint. Is that of disorderly conduct allegedly happening on October 21st of 2020. Cut right to the chase on this. I don't believe it does constitute disorderly conduct under our case law. I am hard pressed to make a finding that Mr. McCullough's words, more than his actions, certainly, but it was mostly the words, crossed the line and constituted disorderly conduct under our case law and the statute. That being said, Mr. McCullough, you got what you wanted. You were arrested. You were poking away at them. Poke, poke, poke. You just continued to do, it was a provocation. As the court had said in one of.
So this judge is saying, is trying to say, well, you kind of egged it on, you was poking at the bear, and you know, why wouldn't the judge tell the officers they need to have a higher level, they need to have thicker skin, they need to have a higher level of tolerance and patience because they are in a position that requires it? How you gonna let them have this? How you got people in a position like this that are more fragile than everybody else? They're more fragile than normal people or people not in this position. They're supposed to have a higher standard.
These other cases, the reaction was justifiable, but it was not.
The action was justifiable, but I'm assuming she's going to say, but not lawful, which is come on now.
Considered to be illegal.
Listen to
As
this.
the court had said in one of these other cases, the reaction was justifiable, but it was not considered to be illegal. It wasn't disorderly conduct on a legal basis, but it was provocation. And there was a response to it, right or wrong. But it was something you essentially had opened an invitation to.
This judge needs to get off the bench immediately. I can't believe she said that. She's supposed to be impartial, non-biased. She's just supposed to go based on the law. What is she talking about? This, oh, blah. Nobody cares. She's not supposed to bring her personal feelings into this. This is a courtroom. Did he break the law or not? Was it justified or not? The answer is no, he didn't break the law. Yes, he was exercising First Amendment right. And no, him being arrested is not justified. That's why you are not charging him with the crimes that he was charged for. But yet she's still trying to do, like, this makes no sense. She's just supposed to just do her job. But you see how that, and this is why you have to understand that you can be 1000% right and go and you get to a judge that doesn't understand the law, doesn't believe in the Constitution that she swore to uphold. The judge also swore to uphold this same Constitution. Yet she's speaking against it and justifying the officer's actions just because they were, she trying to say that he was poking at them. Like, come on, man.
So they did it. They arrested you. So, but you're not guilty of disorderly conduct.
You did. So they did arrest you, but you're not guilty of, which means it's a false arrest, which means they committed a crime. So are you going to speak about the crime that the police committed?
Conduct. And that's it. Thank you.
John is now suing the officers, the city and the state, as well as the police department, citing 15 counts. But the most interesting of all is the request for damages against each individual defendant. As often, when an officer loses qualified immunity, the city will still pay a judgment through the taxpayer or tax-funded insurance policy. This is known as indemnification and is perhaps a worse plague than qualified immunity. And so, as this lawsuit continues, I'll be sure to let you know, but let me know what you think in the comments down below. Check out the resistance by using the provided links and check out another video linked on screen.
I can't believe the judge said that, man. Hold on. Let's
Disorderly conduct.
final words one more.
This is the reaction. As the court had said in one of these other cases, the reaction was justifiable, but it was not considered to be illegal. It wasn't disorderly conduct on a legal basis, but it was provocation. And there was a response to it, right or wrong. But it was something he was.
And I just thought about this. Since the judge has said that, now these officers are going to go back as if they were right, but they lost the case. So they still, but the way she's saying it, makes it to where the police don't have to take any accountability for what they did.
Essentially had opened an invitation to. So they did it. They arrested you. So, but you're not guilty of disorderly conduct. And that's it. Thank you.
That's all she should have said. They arrested you, but you're not guilty of the crime that they arrested you for, which means they committed a crime.
John is now suing the officers, the city and the state, as well as the police department, citing 15 counts. But the most interesting of all is the request for damages against each individual defendant. As often, when an officer loses qualified immunity, the city will still pay a judgment through the taxpayer or tax-funded insurance policy. This is known as indemnification and is perhaps a worse plague than qualified immunity. And so, as this lawsuit continues, I'll be sure to let you know, but